Hi everybody, really pleased to be with you today. I'd like to pay my respects to the Ngunnawal people and their elders past, present and emerging, and acknowledge that our sovereignty was never ceded on these lands. I'm based at Monash University, where I'm a senior lecturer and just finishing up as an ARC DECRA Fellow. This presentation is focused on children at the nexus of child protection and youth justice systems. So it really extends a program of research we've had ongoing with the Victorian Children's Court since 2016, which was initially funded by an AIC Criminology research grant. And that was extended by the Australian Research Council, who allowed us to continue the research further with a DECRA fellowship. So the research I'm going to present to you today isn't quite published because we've been waiting for ages, but nearly there, hopefully, fingers crossed. And it's really looking at children in the youth criminal court and the differences in their characteristics based on their child protection system involvement. And it's currently under peer review, as I said. So this group of children I'm now leaning towards calling dual system youth, which I'll explain in a moment. But what we know about this group of dual system youth who are at the intersection of child protection and youth justice systems is that when a child comes to the attention of child protection services in Australia, they're at least 9 times more likely to later come under the supervision of youth justice systems. If you look at any one time around Australia in our youth detention centres, at least 50% of the children there are known to child protection services. Compared to other children in child protection systems, they often have multiple child protection reports, and we know that they tend to have an earlier onset of criminal justice contact compared to other justice-involved youth. And they also experience greater justice system entrenchment. So that's both in the youth and adult criminal justice systems, unfortunately. So despite a really long-standing awareness of this particular trajectory, and I'm sure most of the people in this room have heard about it through various inquiries and royal commissions, there's been very little done to disrupt the pathway, and certainly very little in terms of responsiveness from the justice system end of things about what differential responses might be required for this group. So this is, an area we're seeking to address. What we also know about this group of dual system youth is there's an overrepresentation of First Nations children and females in this group. So if we're going to look at pathways of First Nations children and females into youth justice, we have to be addressing this pathway and the responsivity factors to it. So I mentioned I'm going to be using this different terminology. I was running for many, many years with the terminology of crossover children. I was sternly corrected by researchers in the United States that we no longer use that terminology for various reasons. And so this is from the work of Denise Hertz and colleagues in the US, who now term this group of children dual system youth who experience that dual system contact. In the current study, we're defining this as children with at least one statutory child protection order in Victoria and at least one police charge leading to their children's system court involvement in the criminal division. This group of dual system youth can be divided into children who are dual contact youth, who have non-concurrent involvement across both systems, and dually involved youth who experience concurrent system involvement across those two systems. So in the case of dual contact youth, what that typically looks like is an earlier level of child protection involvement that closes and then later involvement with the justice system. And in case of the dually involved group, there'll be at least some time of overlap of the child across both systems. So what do we know about dual system youth and how they differ compared to other youth involved in the justice system? Well, there's been some key research that has shown some differences in socio-demographic factors, family, household and child welfare factors, individual support needs and offending behaviour. Specifically, what the research tells us, previous research about the differences between dual system youth and other justice-only youth who don't have child protection involvement, is that dual system youth are more likely to be younger, female and from First Nations backgrounds, as I stated previously. There's some research showing a greater level of family and household challenges, for example, exposure to domestic violence, a greater level of individual support needs, for example, in relation to mental health, more violent offending, greater levels of recidivism and custodial placements for this group, which is really particularly important for us to be addressing if we're going to, do anything about that greater level of entrenchment. Only 3 Australian studies could be located that had looked at these differences previously, one by my lovely colleague here, Dr Malvasso, but these have solely focused on children in out-of-home care and custodial settings. So what I sought to do with this research is to broaden that and look at all children before the criminal courts and all children who had had any statutory child protection involvement. So they might have still been at home with mum and dad, not necessarily in out-of-home care. And the available research to date has also had really limited attention to key responsivity factors and key risk factors in relation to education and support needs. So that's another couple of gaps we're looking to fill with the current study. So the aim was to identify the differences between that dual system group of youth and justice-only youth, and also to look at differences based on the timing of their system's involvement. So differences between children who had that concurrent involvement and that non-concurrent involvement. And the areas that we were looking to explore differences around were around socio-demographics, child welfare involvement, support needs, and children's offending profiles. What is the purpose of this kind of research? Well, as I've stated previously, we know that there's a really high proportion of child protection involved children that come into contact with police, youth courts and youth criminal justice systems. So these systems each require really up-to-date and adequate and evidence-based, data to, manufacture their responses to this group of children and young people, and to plan those differential and targeted responses that can better suit this group of children's needs. The findings could inform police, courts, youth justice, but also broader community services that work with this group of children and young people in terms of appropriate prevention strategies, evidence-informed service delivery, and also targeted therapeutic strategies which really don't exist currently across Australia. So the study sample, there's really two. So the first group is that dual system sample, which we collected a few years ago based on the research funded by the AIC. So this was a group of 300 children that came before 3 Victorian Children's Court for criminal matters in 2016-17. And they could be divided up into 128 children who had experienced non-concurrent involvement and 178 children that had concurrent involvement. And then more recently, I collected data for that justice-only group. So they were children who were matched by the same courts and the same time period, but who hadn't had any statutory child protection involvement in Victoria. Over the course of collecting that data, I found that there were some children that had child protection involvement in that group, either like non-statutory involvement in Victoria, other involvement in other Australian jurisdictions, or indeed I found a few children that had come from other international jurisdictions where they had, for example, grown up in an orphanage or been adopted internationally. So excluded any children with known child protection involvement or child welfare systems involvement, just to really try and get a picture of the differences between the groups as clearly as possible. So that left a group of 268, what we call justice-only children in the sample. So what data were collected? I do not recommend doing this. It's very labour intensive, but it actually produced some really interesting findings, although also a very sad and tragic process to actually see children's trajectories through these systems. I looked at children's electronic and hard copy records for the dual system youth, collected data from both their family division files, which were their child protection files, and their criminal division files, and for the justice only group, went to the criminal division files only. As you can probably imagine, there was really wide differences in the data availability and quality across all the variables we were seeking to look at. So where the data availability and quality was really high, we used data from the whole sample. For certain variables, I just went to the data from children that were subject to a youth justice supervisory order. And the reason for this was because this group of children had all received a youth justice pre-sentence report, which had really collected quite consistent data across a range of variables like their offending and their response to it, their family situation, their education, and so forth. So we could rely on that data being a lot more consistent for that group of children that came under youth justice supervision. The advantage of that is also that that's, I guess, the more pointy end of things, and where we can have, I guess, the biggest response, and where the need is rather bigger. So the findings across the whole sample, I hope you're liking the pink font. I figured it was going to be afternoon and people would be tired. Also, I like pink. So the first set of findings around children's gender and child protection system involvement, consistent with the previous research, dual contact and dually involved children were twice as likely to be female compared to justice-only children. There were certain aspects in terms of their child protection involvement where we saw no differences between the different groups of dual system youth. So there was no difference in their age of first notification, how many notifications or substantiations they'd had, or the age of their first out-of-home care placement. But where we saw differences with the dually involved group, who were concurrently involved across both systems, had more maltreatment types, so more different maltreatment types, what we call polyvictimisation, and more out-of-home care placement, as we would expect, compared to dual contact youth, whose child protection matters were closed. In terms of their age of court and priors, the dually involved group were substantially younger than the dual contact group and the justice-only group, who were about 17 years compared to 5.6 years. The graph there shows a bit about their priors. So on the left there, data concerning whether they'd had a prior diversion or sentence. So just over 1/2 of the dual contact and dually involved children had a prior diversion or sentence compared to just over 1/4 of the justice-only group. And in terms of children who were aged under 14 years old at first police charge, nearly 1/2 of the dually involved group were aged under 14, compared to a much smaller percentage of the justice-only group, for example, just 12% of that group. So that's got implications for around raising the age of minimum age of criminal responsibility. In relation to their current police charges, we looked at both broad police charges and certain specific charge types are of interest in relation to the dual system youth cohorts. So where there were substantial differences were that the dual contact and dually involved groups were more likely to have violent charges, property charges and justice procedure related charges, so breach of intervention orders and bail orders, for example. We also specifically looked at the charge of criminal damage as a type of property charge and found significant differences there, particularly with the dually involved group more likely to be charged with that type. There's been a lot of literature concerning the use of police responses, particularly in residential out-of-home care settings, where children might have behavioural challenges that are responded to through that justice response, quite often leading to this particular charge of criminal damage. And the final set of bars there is what I've termed criminal justice system related charges. So I've had a look at what charges children had that are specifically related to their interaction with the criminal justice system. Things like assault police, destroy property in custody, and things like not giving their name and address to police. So again, there were significant differences there, albeit a small proportion, but children involved with the child protection system were more likely to be charged with one of those types of charges. In terms of their court outcomes, as you'd expect, children in the justice-only group were far more likely to receive diversion, 40% of that group compared to 20% or less of the other two child protection-involved groups. That's to be expected given they were less likely to have priors, less likely to have violent offending. But as we can see, a higher proportion of children in the dual contact group and the dually involved group came under youth justice supervision, which is consistent with the previous research. So just having a look at this final group of children under youth justice supervision for the last set of findings. More pink. So caregiver at current criminal court matters. So this is an important thing to look at because it hadn't really been looked at in previous research, but a lot of the more qualitative research showed that children in the child protection system were less likely to be supported at court and with their court matters. And this really shows how that plays out. So the dually involved group, 60% of those were in residential care at the time of their criminal matters, compared to 62 to 69% of the other groups who had a parent with them at the time of those matters. How this played out, other than the level of support they had at court, I did have a look at whether or not children had a support letter in their criminal files, in their court files. So a support letter from a family member, from a friend or from an employer. And even though the numbers were pretty low across the board, they were still much higher amongst that justice-only group compared to the other two groups. So less than 2% of the children involved in child protection had a support letter from anybody, whereas that number was up to 9% in the justice-only group. So small numbers, albeit, but it definitely shows the level of social connectedness and support differs between those groups of children. Engagement in education was another area we sought to have a look at. And again, you can see a similar pattern emerging. The dually involved group, far less likely to be involved in education, far more likely to have experienced alternative education, to have required classroom support. So that's typically a one-to-one aid necessary concerning behavioural issues, disability-related issues and so forth. And the group of dual contact and dually involved children much more likely to experience school exclusion relative to other justice-involved children. So again, key risk factor we know in recidivism and far more prevalent amongst this group. And the final set of data I want to present is around support needs. So the first one being neurodisability. Again, the pattern here is similar. The dually involved group far more likely to experience neurodisability, 2/3 of this group, particularly significant differences concerning the prevalence of learning problems and ADHD in this group relative to the other two groups of children. Mental health and drug and alcohol related needs, again, similarly the dually involved group, more likely to have any mental health need, but also have a higher prevalence of most other types of mental health needs, particularly in relation to self-harm and suicidality, which is a consistent pattern you also see in custodial settings, and also substance misuse. So this is consistent with previous research, but I also sought to look at the cumulative level of needs. It's not sufficient for us to look at the prevalence of individual needs, because it's often the cumulative level of needs that lead to that complexity that can lead to children being excluded from services, handball between services, or slipping between the cracks, so to speak. So if you look at the children, the prevalence of children with all three of these needs, neurodevelopmental disability, mental health and drug and alcohol needs, 46% of the dually involved group have all of those needs, relative to only 13% of the children solely involved with the justice system. So I guess that really demonstrates a much higher level of complexity of support needs amongst that group of children and young people. So what are the implications? Well, certainly that earlier contact in the dual system youth with police has significant implications concerning raising the age of criminal responsibility, as I said previously. The more serious offending profiles of dual system youth certainly reflect the cycles of violence that we've heard a lot spoken about in this week's conference around a lot of the DV kind of talks, but also reflect potentially the greater level of surveillance of this group. I was attending a talk about adolescent family violence in the home, and was really apparent that only a very small proportion of those children who are not in the child protection system will come to police attention for using adolescent family violence in the home. I think the number given was 20% coming to police attention, and only one of those children having actual charge brought against them. This is not what we see in children in the child protection system. So that level of surveillance really has a part to play, and we need to be taking that really seriously. Also, the greater prevalence of criminal damage and justice procedure offences really, I guess, makes sense with regard to the narrative concerning the criminalisation of trauma and disability-related needs in this cohort. The greater prevalence of criminal justice system-related charges might speak to greater training needs that haven't been met in youth justice support staff and also in police, not just concerning trauma, which I think we're a bit all over at the moment. I think there's a lot of narrative and a lot of talk about trauma. I'm not sure that's matched by the level of understanding concerning disability-related needs in these cohorts. So the high level of support needs among dual system youth is certainly related to their lack of support from a key consistent adult, particularly those that are dually involved across both statutory systems, their educational disengagement and exclusion, and the complexity of their support needs. And it's important to understand that the greater level of support needs are evident even when compared with other so-called high-risk youth justice populations. So I think some of the narrative I've heard is that, well, the needs across the dual system youth cohorts simply reflect what we see in youth justice populations overall. I hope this data makes it clear that that's actually not the case, and they do present with a higher level of needs and complexity. Limitations of the study is that it's cross-sectional data, we can't determine causality, and the prevalence of support needs is actually likely to be an underestimate because children were not individually assessed. There might be other children in the justice-only group with non-statutory child protection involvement that we didn't pick up on, and there was substantial missing data in relation to Aboriginal and Torres Strait Islander status that really stopped us from drawing any conclusions about that group of children and young people. The policy implications is that dual system youth, particularly those that are dually involved across both systems, really require tailored service provision and responses to better meet their needs. At a minimum, that service provision needs to attend to their multiple and complex needs, both in the provision of therapeutic responses, but also, I think importantly, in relation to responsivity. The fact that we see a high level of recidivism in this group might be due to inattention to the responsivity issues that are actually stopping them from engaging with justice system programs. Any service provision also needs to address barriers to multi-agency collaboration, because as we can see, this group have multiple and complex support needs, and so there's a preference there for holistic models to respond better to this cohort. There are my details. Please feel free to get in touch if you want a copy of the paper when it's finally published. I'm happy to take any questions from the audience.